straw man Fran is. Ooh, isn't that neat? Have you gone through it yet?
No, not yet. I went through the other one
Okay.
last year, the year before.
Okay, back on again. Okay, in the metaphor we were using, had she sent 50,000, she would have double created the money. Now what they did is they took the 25 in and then they sent her back a new bill. When they sent her back the new bill, they were licensing the creation of the funds all over again. So what I'm saying is there's no problem with her now sending back the new amount, the 25,000 plus they're adding penalties and a bunch of other happy jazz in there. So what difference does it make? Full acceptance, I'll authorize that again. Otherwise, she's in dishonor to these people by protesting in violation of Matthew 17. So what this lady basically can go ahead and do. Now, here's one of the things that I was talking with some of the people. Remember when Elvick said that what you need to do is change of address. Now, we'll assume and presume that this nice old lady here went ahead and has put in a change of address and some things like that. Here's what I said to my one friend. Maybe the reason they sent this check back to her, who was it that closed the account down? Do we know if it was the bank? Who else might it have been? The IRS. The IRS may have said, close this lady's account. Let's say that the IRS directed the bank to close that checking account. Who's the creditor on that closed checking account? Why do you assume she is the creditor? Did she, in fact, draft them to close that account? No. Remember what Elvick said about change of address? Every time an account manager sends out a bill for an account, it's usually because there was at least a debit posted on the account during that month. And if a debit was posted on an account during the month, what is the status of that account? It's open. Even if you completely paid it off with asset funds on the closing date of that preceding month. So every month, these accounts, like utility accounts, can open and close. If you paid them with asset money, they would close that open account every month if you footed the whole bill. And the account remains closed. And then there was some energy on the public side used on that account, which means they're going to debit that account for your electricity, your water usage, whatever it is, and it's going to reopen that account the next month again, right? If you come back with asset money payment and pay that bill before the closing date, it will close that account and put it on the private side. When that account is on the private side, who's got the title to the goods represented by the transmission of that account? You do. Because you paid asset money and closed the account. Okay? Now, the account is operated through the straw man. But it's the living soul who has the exemption, who can use the asset money to pay the bill in asset money and close the account. Now, the account was opened presumably to the straw man, and what was the address for that account? What was the jurisdictional venue? The Public Territorial Bankruptcy Zone, OH. So you as the creditor, if you're going to close that account by asset funds, must give the account manager notice by a, quote, change of address that the funds are being paid not through OH, but through OHIO. So you send a notice of change of address. the next time the bill comes, it'll still look like OH. But the difference is that the creditor has in fact informed the account manager the correct address for the account. And as such, it rebuts a presumption that the account is in the bankrupt territory. So a presumption has been replaced with a fact certain because the one who reported the facts became the creditor on the account. Likewise, if somebody's going to close down a checking account in the bank, the one that goes to the account manager, if it's the IRS, and gives instruction to close the account, who appears as the creditor on the account? The one who gave the draft to close it. So if the IRS instructed the bank to close the account, the IRS looks like the creditor. Now let's assume that the IRS instructed the bank to close the account and it's going to operate this account as a creditor. What is the IRS going to do? It's going to pay the debt because it's the creditor from the closed account. So whereas the woman wouldn't pay, the IRS could come in and instruct the bank to close the account, and then it can make adjustments and set-offs from this woman's private exemption without any more authority and permission from her. Now, she goes out and writes a check on this closed account. Is she the creditor? No. Is she authorized to write checks on a private account in which she's not the creditor? No. Is it possible that the IRS sent all this back to her in order to inform her that she does not have authority to do what she's doing because she's not the creditor on the closed account? Now, how could she get to be the creditor on the closed account? Except the closing of the account from the IRS, reclaiming the exemption. Then write the check. She doesn't have to go back to use debits, but what I'm suggesting is, see, a lot of times when people have written checks on a closed account, they never, ever, ever get their check back. And the fact that they don't get it back, here's what one woman did. She paid off a credit card, an open credit card account with a check on a closed checking account in a different bank. And the credit card company called her up and said something like, your check's no good. Now remember, on the public side, a closed account to the public appears to be, quote, no good. Because the fact that it's closed means to the public it appears not to be there for public purposes. You're not using it to publicly pay your debt. You're using it privately for set-offs and adjustments to close the account on the private side. So they came back and said, on the public side, your check's no good. You have to send us another payment. And here's the amount. And this lady goes, well, I accept that conditionally upon proof of claim that that check I sent you was no good. And they said, well, it was on a closed account. It's no good. She said, then it was useless to you people? And they went, yes. Then return the check to me, and I will send you another one. Oh, no, we can't do that. It was destroyed. Hello? You don't go around destroying evidence. Now, If they said it was destroyed, what are they telling you? It's already been set off and adjusted. We've been paid once. We can't return it to you. It contains the evidence of the payment. Duh, what did this check do? Went through all the banks. They said it wasn't accepted. Let me ask you a question. Do you think there's any bank in the world that's stupid enough not to accept the tender of the check? Every bank will accept the tender of the check. Remember the car sales company that says every application for credit will be accepted? Does that say every credit app will be approved? No. Every application for credit will be accepted. We will turn no one's application down. Because if they did, isn't that, in essence, a violation of equal credit protection for all? So they have to accept every application. Okay? They have to accept every check tendered to them. Okay? Now it came back and it said account closed. That can only be good news or better news or best news. Because if they admit the account's closed, then it's on the private side. See, if you close your checking account because you're going to do asset money payments, what is the first thing that the government agents are going to ask you when they show up at your door asking you about what you're doing? Other than, is this you? Is this your name? What's the next thing they're going to probably ask you? Did you write this check on this closed account? That's probably the first thing they're going to ask you. What's the answer? Absolutely. Okay? What's the next thing they're going to ask you? No. No, they're not going to ask you, did you intentionally try to defraud them? That would be an accusation in violation of James 4:11. They're not going to ask you, do you have any more liability money? That's not the issue. No, they are not going to ask you, do you have any other accounts in that same bank? At that stage of the game, they don't care about whether you wrote other checks. Very close. Did you know it was a closed account? What evidence do you have that the account was closed? The difference between people getting into major big trouble and going through their system and people that aren't in major criminal liability going through their system is you better have evidence from them that you have to evidence that the account was closed. Because it's insufficient to suggest something. If you suggest it, you have to be able to prove it. So what's the evidence that the account was closed? Remember, when Elvick was doing this, the judge in that one criminal case said, and what evidence did you have that the account was closed? And he said, I had a letter from the comptroller of the bank. Think that's good enough? Most likely. So you can produce evidence that the account's closed. It's not that you ask them to do it. And, hey, diddle, diddle, a cat and a fiddle, and a cow jumped over the moon, and maybe it was, and maybe it wasn't. They should have done what I said. The question is, what evidence do you have that the account was closed? Okay, yes.
Yeah, I'm in the middle now of closing one with Charter One Bank. And they sent me round and round last week when I withdrew my funds, and all they wanted to give me was my little stamped thing showing that I had withdrawn all my funds. And the head teller came over, and she says, well, I can't write you a letter. She says, I can't mark anything certified. We don't have any stamps. And I said, well, that's interesting. I said, could you check with somebody else? I'll come back. So I finally called them today, and they said, I called headquarters, and Gal gave me directions to tell them that they were to do a letter and have it notarized. So I'm saying, okay, I think a notary signature would be good enough. Mm-hmm. So I will be picking that one up tomorrow.
Super. Notice how banks can't certify anything anymore? That's how bankrupt they are. Yes.
Suppose an account was closed for at least 10 years. Can that be used?
Understand this. Since they're bankrupt, they can't close anything. Remember, there is no definition for a closed account. There's only definitions for open accounts. And as far as they're concerned, there's only open accounts which are in a condition of being closed. That's only because debits and credits haven't been posted. And as soon as a debit and a credit posts, it reopens the account. The only time you probably can't deal with a closed account is when the bank itself in which the account existed no longer exists. So that there's probably no routing numbers and system of accounting there in their offices that keep track of what's going on.
Huntington is still well and alive. And that's where it was at.
Yeah.
That same bank she was talking about, I had one with Chartered One. Do you have to accept this for value privately before you close it or not?
Well, the concept is, there's several thoughts on that. When it comes to your registration on the UCC, if you registered your employer identification number, i.e. your SSN without any dashes, if you registered that, everything that you open in terms of any account is usually based on that SSN. So if you registered your employer identification number and used the language of all I forget what the exact language is, all offsets and properties and rights and this, that, and next thing. Basically, any account that's got that number on it is already pre-registered. But if you wanted to do it, you could put like a bank account number on a UCC as a property right of the straw man, of the debtor, and that registers it outright. And then basically you should be letting the Secretary of State know what these accounts are that are registered. And remember, that goes into what we said earlier, this UCC 8401 registration and taxes paid and the whole bit. See, the reason you're paying the taxes for the registration is because by paying the tax, you're actually clearing the trustee fee, which is a common law lien, against the account or the property. And so by paying the tax, you're actually establishing the elimination of any trustee's lien on that account. And so now it truly is a registered security. So you can register securities, let's say as a corporation, in which the corporation is a pure fiction of the sons of Cain, and now you've got a registered security like a stock on the stock exchange, but are you really the creditor to that stock that's registered? The answer is no. All you are is a public entity registering a public stock. So what you're doing is you've got a higher priority of leverage in the public debtor system. You're just higher up the pecking order of debtors within the public system. Whereas when you're doing the private registration like we're talking about doing here, you're actually pulling that title over onto the private side with the claim.
Okay, again, then like you was saying, Chartered One, when I closed an account there about 2 years ago,
okay,
I asked for the return of the signature card, which they gave.
Okay.
Would that be evidence of closing?
Might. See, what's interesting about this check that come back for that woman, it's got account closed right on the front. Now, see, here's the problem. That's colorable. The account's closed. Yeah, that may be. Let's say they closed her account. but she isn't the creditor on that account because she didn't close it, see? Okay. But you have to have some evidence that you are the one that closed it, because if that's what's going to happen, you need to do that. And remember, the evidence that you got to present is evidence that you present that comes out of their mouth, not out of your mouth. Because your evidence doesn't make diddly squat in the land of Cain. Yeah, you got the original signed signature card returned, but I don't know. You need evidence from them that the account's closed. It's got to be in their words, or in their officers, or through the notary is their public witness. So if you're getting a letter with a notary on there, the notary comes from their venue, which is third-party testimony as to the facts being stated thereon. The point is, like this gentleman before said, okay, if you close the account and you start writing checks and they come after you and want a proof of claim, how are you going to prove your claim? Well, the answer is not through your testimony, buddy. What you're going to use is you're going to use all the evidence that comes from them. That's the proof of claim. Through third parties. It's not through you. And that's exactly why, if you close this account down, the second question they're going to ask you is, what evidence do you have it's closed? And if you tell them what you did, you're testifying, you go straight to jail, do not pass go. Because you do not have any evidence, you've just dishonored them and become the debtor, in fact, by testifying. So they say, what evidence do you have? You better bring a third-party piece of evidence out of the son of Cain's system that says the sons of Cain know the account's closed. Pete, you're not on the mic, my friend, and these are important issues. Can she take her notarized letter and file it with the UCC? Yeah, possibly. Okay. I'll talk about something else with that in a second here. This is another thing that came up this week that's really neat. You got a question first?
Well, I wanted to ask, since he has the card with the signatures on it, couldn't he photostat that card and get it notarized and send it back to the bank and have control over it at that point? Wouldn't he have control over it at that point if he notarized it, had the photostated and had the notarized and then sent it back to the bank? Now he's the creditor because he holds the original card. And that's proof that the account is closed.
Well, you're going to hold a notarized copy because you need the evidence. You could send that back to them, a copy of it, and that will evidence what's going on. But I think the real issue is somehow or other the Secretary of State ought to be brought into the loop, because he's the one that's going to notice the property and the accounts for the aliens. And you, as one of the sons of God, are alien to the sons of Cain. And what the Secretary of State does is he represents the aliens to the sons of Cain. So he's representing you. He is your agent. And so if he has notice that that account was closed down and is on the private side, he's the one, along with the banking system, that's going to make the necessary notices to that financial account to make it appear as though that account is available for private adjustment and offset.
Well, could he receive one of these photostatic copies?
Yeah, he could get a copy of it and then notice it.
And where it says OHIO on it rather than OH?
Yeah.
And that wouldn't...
Sure. Okay. Yes.
Okay, on my original UCC, I did put on there adjustment of this filing is from public policy, AGR 192 UCC 10104. All proceeds, products, accounts, fixtures, baggage, etc. on orders.
There you go. That includes that.
Would I still need to send that just to be
probably
myself?
Giving the Secretary of State notice that account in particular is included pursuant to that filing and stuff. It appears as though whatever's going on is going on because they're doing something to the computers with respect to those financial accounts, so that the computer understands that it's a closed account privately accessible rather than a closed account that's still in the clutches of the public banking system.
Okay.
See, ordinarily, if an account closes and you're not closing it, specifically by claiming it, then that closed account, you're not the creditor on that account. The banking system is. And the banking system is the agents for the international creditors. So basically what's happening is if you just allow an account to drift down and close, and you don't send the notice for closing that account, you're not the creditor directing that account.
Okay, when I send him a copy of this, is there any particular wording I should use, or just say something to the effect of take notice?
I just put a short cover letter, please take notice. This is one of the accounts included within that particular Secretary of State filing as a finance statement. Okay. And then just instruct him to either adjust, offset, or whatever your records accordingly.
No, there should be no other consideration involved then. No monetary.
You need to. It's just notice name.
Yeah. Okay. Great.
Well, yeah, you could close accounts with regard to stock certificates. They closed it on you. Well, you know, if they closed it on you, then it's a closed account, but it's on the public side for the international Sons of Cain creditors. It's not for you. See, in the third edition of the redemption manual that comes out of the guys down in California, they're talking big time about really registering your straw man as a trade name. And there have been several other cases that I've talked to Rick Schramm about too, where people have placed property rights for artistic or creative things, like things that might be registered as a trade name or might be included as a patent with patent agency. They put that instead of trade name or instead of patent, they have placed it on UCC registration filings. And we've seen some court cases, like out of bankruptcy court and some other places, which have basically stated, you kind of read between the lines and they don't want to tell it to you too directly, but they basically said that these other places, like the patent places and the trademark places, certainly have authority, but then it appeared like subject to UCC filings, as though as, hello, which one came first and what's going on? And it's kind of like they don't want to let the cat out of the bag and say, oh yeah, the best thing you could do would be register it on the UCC. But you got to understand that the UCC is the private side, basically, unless you're a public corporation with no exemption. And the patent office and the trademarks are for the corporations. And so what they've done is they've given a public agency like the trademark office and the patent office to protect the rights of corporations. But the problem is the corporation the ultimate creditor? And the answer is absolutely not. A corporation or an entity, a fiction entity, basically has no exemption right. It's a creation of the state and or whatever, unless some living soul takes it over and acts as its guardian or underwriter. And so basically the UCC gives you private creditor rights, whereas the patent office and the trademark office gives you public. Now, if you did your original filings with the UCC, basically what you're almost doing is a trademark registration of your straw man. That's what you almost should have been doing with your original filings. So you really shouldn't have to come back and do this like trademark crap again. But that's what makes it powerful, because you're claiming that right. See, any entity that goes into commerce, it has to use its name in commerce. Its activity in commerce is by a name. If you go down, let's say, even to the cash register at Radio Shack today and try to buy something, it's darn hard of them anymore in their accounting system to not put a name on the receipt or put cash on there. They'll say, I need a name. And there was a guy in line in front of me this week, and he said, Fred. And the guy goes, that's it. That's enough. I don't need any more. I'll make it out to Fred. It doesn't make any difference how many letters are in the name or if there's numbers in the name. They need to put at least one digit of a number or a letter down there as a minimum in order to create the presumption that there was a named entity doing commerce. Okay? All commerce is conducted through a name. So when you go into commerce, you're going into commerce by necessity with a trade name, trademark. Well, they want the zip code to find out what venue it's from. Okay? And of course now Circuit City has started taking down a history of data because they're trying to impress the average shopper that you can lose all your paperwork. We got all your information now for your warranty and stuff, and so it asks you 1,000 questions. But they need at least a 1 or 2 digit letter, numeral, sign, something to create the trade name that's involved in that commercial transaction. Yes.
Couple things. Am I better off to drop all names in regards to my farm business?
Why would you drop names?
So I'm not really identifying myself as in commerce, making myself high
Well, you
profile.
are in commerce. If you sell one pumpkin or a bag of corn, you're in commerce. It makes no never mind.
Okay. And define exemption in the way that you were using it in relation
Your exemption
to the
is
corporation.
Your exemption is what you got from the Messiah because he paid your debt.
What about the corporation? You said it.
Corporations have no exemption. Corporations' life activity is to get you to give up your exemption to them so that they are exempt from the tax based on your exemption and you volunteer to pay the tax in their place. That's exactly what they're doing. The IRS is a corporation soliciting your exemption. They will get your exemption one way or the other.
Why no dashes between our Social Security numbers? You said earlier, no dashes between the numbers.
Because if you put the dashes in it, you're asking for a social benefit, which means you're acting like a debtor instead of a creditor. The creditor is an employer. A debtor is an employee. If you put the dashes in it, it appears as though you are an employee debtor. If you put no dashes in it, claim it's your employer identification number, you are coming in on the creditor side of the account instead of the debtor side of the account, which means that you're operating the account instead of them. Yes?
What about, recently we were saying it was 2 digits a dash and the rest of the digits was the employer ID number. Are you saying that that's not correct? It's a solid number?
I just make it a solid number.
Okay.
Let them do whatever they're going to do with it. Okay? Also, if you try to put Social Security numbers on UCC filing, they will not go through. For some reason, particularly since the beginning of July, any apps that have Social Security numbers on, they're blacked out. They will not allow those to go through. If you put an account number and put the same number down there and call it an employer identification number, it's usually gone through. Because it's an oxymoron. If you put a Social Security number, you're on the debtor side of the account. Why? You're a legal lunatic. Why in the world are you trying to manage the debtor side of an account? Have a friend. This guy, his wife, several years back when he filed his UCCs, his wife signed off, and her straw man was included as property on her husband's UCC. So the husband's UCC1 account, the living man was the creditor, his straw man was debtor number 1, her straw woman was debtor number 2. Subsequent to that, this crazy lady got a bug and divorced him, or wanted to. And when she filed for divorce and hired this woman attorney. The woman attorney filed a divorce petition in the court. My friend accepted it and informed the divorced lady that he was not going to respond to the court, that the state didn't have title in this marriage, and that he wasn't walking into the court, and where did she get her permission to trespass on his property? So the woman lawyer threatened a bunch of stuff and said, I'm going into court and I'm getting a contempt against you. She went into court, and evidently she didn't get the contempt because she came back and called him on the phone and said, oh, please, please, don't you want to settle this? Won't you please agree and allow us to do this? You don't want to remain married to your wife that doesn't want to remain married to you, etc., etc. And my buddy goes, I don't know who the hell you are, and I don't know who the hell gave you authority to trespass on my matters. Buzz off. To which this woman lawyer eventually came back and sent him notice that she was going to petition the court for a bifurcated divorce. We talked about this probably a year or more back. And my friend's going, bifurcated divorce? What the heck is that? So we looked it up in Black's Law Dictionary, and sure as shooting, there's bifurcated divorce. And under bifurcated divorce, what it basically said is, that was a divorce in which the officials in one venue and jurisdiction can grant a divorce basically between the parties that applies to that venue and jurisdiction. However, having no authority over the property or distribution of property, that area of the divorce remains unsettled. So basically what they said was, if you want to come into our corporate state and get a divorce judge to declare you divorced, as far as the laws of our corporate state are concerned, we'll be happy to do that. But we can't resolve the property issues, we can't resolve custody issues or any other issue, because we don't have jurisdiction. So basically, the corporate state granted a bifurcated divorce. And this woman's gone, oh goody, I'm divorced, and went her way. Now, the property that was included in the marriage was all listed as property of the straw men who were debtors to the secured party creditor, the living man. This woman went out and thought she could sell her car, which she took it down to a car dealer and said, this is my car, I want to sell it and trade it in on another car, and did that. When my friend followed her tracing of activities a couple of weeks later, and went down to the dealer and said, what the hell's going on here? You're messing with my property. And the guy said, no, this is this lady's car. He says, it may be her car, but here is the registration on the Uniform Commercial Code, and she hasn't got authority to release it. And the dealer goes, oh my God, you're absolutely right. That car is still yours if you want it. And so this issue is not about what's going on with that car. This issue is about a year or so later now. And it gets to be real funny because what happened is this young couple was living in this home. And their names weren't on the property. In fact, they had a friend, a couple, older couple, and these friends had the house in their name, which, as a pure favor for this couple, they bought this house, had it in their name, because the young couple had some things going on and they didn't want the house seized. So it was in the older couple's name, and the bank mortgage was set up, and every month the young couple paid the bank mortgage by money orders themselves. So the payments were always made on that house by the couple living in the house. The arrangement that they had with the old couple is it was really the young couple's house. And that the older couple were just doing them this favor, and when the young couple got to the point in their commercial activities where they could float the mortgage in their own name, they transfer the house, pay off the older couple, thank you very much. Now this woman gets divorced before they've done anything. So now the guy is living in the house. The wife moved out. And he's going through some rough times commercially, economically. And he's getting to the point where he can't make the payments. So he says to the older couple, listen, I'm going to be short making the payments. I don't want to get you into any kind of trouble. I've been sick. I'm going to go back to work pretty soon. When I go back to work, I'll have no problems paying the mortgage. In fact, I've started going back to work. I've got a good salary. I could qualify for a loan. I'm going to go down and qualify for a loan. I want you to sign the house over through escrow. To me, the bank loan will come in. The bank loan will be sufficient to pay you off what I owe you, what I owe the previous bank from your loan. Give me extra equity so that it will help me make my payments until the bigger money's coming in a couple months down the line. And the guy of the older couple says, fine, all I will need is a release from your wife. To which our buddy says, excuse me, she's already released it. I'm registered in the UCC. She is the debtor. To me, the creditor. I have power to do whatever. She has no power. The older guy says, well, I don't understand the UCC, and that's not good enough for me. And I want a release from her, because if I don't get a release from her, and I do what you want, and she comes back later because she's mad at you, and then mad at me, and sues me, I don't want to have any trouble. And my friend's saying, I'm telling you, go to your attorney. She's already made a release. And so the guy went to a first attorney, and this first attorney said, what's the problem? And the older couple said, oh, the young couple is splitting up. The wife's taken off. They used to be making the payments. They're not making the payments anymore. Now I got to make the payments. It's burdening me. And the attorney says, don't worry about it. I'll handle it. Next thing you know, my friend is served with a notice to pay up or quit the property. Hello, what's this? What are they really asking? They want the property under what presumption? Why do you send a notice to pay up or quit? Why do you send that notice? What is the assumption? They're evicting him, which presumes what? That the older couple is the landlord and the younger couple is the tenant. And it's an eviction, a pre-eviction proceeding. What's wrong with this picture? It's untrue. What's wrong about it? Now, remember, it's true that he hasn't paid the mortgage. So all the facts in the notice are true. They're colorable. You need to have an extra fact which is going to turn the whole figure out. So my buddy calls me up and said, what the hell's going on here? I said, the attorney is seeing what you know. They're assuming and presuming a landlord-tenant relationship. Is that the relationship you got with the older couple? He says, hell no. I said, whose house is it? It's mine. Whose name's it in? His. I said, so what fact have they left out? The fact they left out is the older man or the older couple is what? They're trustees. Who's the beneficiary? The young couple. So it's not a landlord-tenant relationship, it's a trustee-beneficiary relationship. Now, according to the terms of the deal, the beneficiaries were going to be paying the monthly mortgage. But remember, our buddy said, I've already got a loan set up, just put the release and the title into escrow, and it's out of your hands. What's wrong with this picture? The trustee isn't giving up the title. He's trying to maintain ownership of the property, which is a wrongful conversion. Okay? So it looks like this guy's out to steal the property from the young couple. So what this guy did is he did a conditional acceptance for value privately of the attorney upon the attorney show